Hello everyone and welcome to our fifth video tutorial on statutory interpretation, and today's video is on the purposive approach. And just as a reminder to you all then, if you recall, there are four approaches or four rules to statutory interpretation, and in previous video tutorials we've looked at the literal rule, the golden rule and the mischief rule, but the focus of today is the purposive approach. And as always, it makes sense to start off with the definition. So the definition of the purposive approach is that it goes beyond the mischief rule. So the courts here identify the purpose of the act, and then they construe doubtful passages in accordance with that purpose. And we've got here a case. This is a quote from Lord Denning, and Denning was very much in favour of the mischief and the purposive approaches. And this was Denning talking about the purposive approach. And he says here, "We do not sit here to pull the language of Parliament to pieces and make nonsense of it. We sit here to find out the intention of Parliament and carry it out. And we do this better by filling in the gaps and making sense of the enactment than by opening it up to destructive analysis." So Denning was really saying here that in some cases, it's not right to use the literal rule, to stick with the plain ordinary meaning of words if they're absurd. That's what he's really saying. He's saying, why are we pulling the Act of Parliament to pieces? Why are we making nonsense of it with absurd decisions? If we know that Parliament didn't intend a particular thing, why aren't judges actually trying to achieve what Parliament wanted? So he was very much in favour of it. If we have a look at a case on the purposive approach, this will help to illustrate really how the rule works. So in the case of Jones and Tower Boot, you can see here from the facts that we had a young black worker who was physically and verbally abused at work. So he was being the victim of racist abuse in the workplace, and therefore he wanted to sue his employer, Tower Boot, under the Race Relations Act of 1976. But the employer, Tower Boot, argued that he was not liable, or the company was not liable, because the bullying was not part of the employee's jobs. Now, what he was getting at here was the words that needed to be interpreted, the words that were in question or in doubt in the Race Relations Act, was the phrase, "in the course of employment." So the Race Relations Act says that it's an offence if employees are committing racist abuse in the course of employment. Now, this phrase, "in the course of employment," means as part of the job. So what the employer is saying here is that if you use the literal rule, they're not guilty of an offence here, because clearly the employer hasn't made it a requirement of the employee's jobs that they be racist. I mean, obviously that would be a nonsense. So the court had to look at how were they going to interpret this act. And you can see here from the outcome that the courts decided, using the purposive approach, that the defendant's Tower Boot Company was liable using the purposive approach. And the judge said that Parliament's intention was to stop discrimination in the workplace. That was the purpose of the Race Relations Act. And they said that that wouldn't be achieved if the words were interpreted narrowly. So what the court's really acknowledging here is that, yeah, technically using the literal rule "in the course of employment" would mean that that the employer's not responsible, because they weren't doing it as part of their job. You know, it was not part of their role. However, if we were to interpret it narrowly like that, it will completely undermine the whole purpose of the Race Relations Act. Because really what the Race Relations Act should have said, I suppose, is that an employer will be liable if the employees are making racist remarks or abuse, etc., whilst at work, not necessarily in the course of employment. So obviously the wording of the Act of Parliament makes a huge difference in terms of whether someone's going to be liable or not. And that's why judges have got to come up with these rules of statutory interpretation. So that case really leads us on to considering the advantages and the disadvantages of the purposive approach. Now, the purposive approach is the approach used by the European Court of Justice, and it is seen as being a more modern approach. The Human Rights Act as well is another example of a sort of more modern piece of legislation that has to be dealt with using the purposive approach. It's described as a living document. It has to be interpreted in accordance with its overall purpose, with the overall purpose of the European Convention on Human Rights. What we've seen in the case of Jones and Tower Boot is that a real advantage of the purposive approach is that it is promoting the purpose of the law. It's leading to justice. Clearly, it would have been really wrong if the employer had not been found liable in Jones and Tower Boot. So the purposive approach is helping us to achieve justice in cases like that. It's also a more broad approach. It's going to cover more situations than the literal rule. It's going to be helpful with situations unforeseen by Parliament. Clearly, if you think about Tower Boot, Parliament, obviously, when they were drafting the piece of legislation, didn't think deeply enough about the phrase in the course of employment, because it would mean that no employer would ever be responsible under the Race Relations Act if we interpreted it literally, because no employer is obviously going to make it part of an employee's contract to be racist. The rule's also very useful where we've got new technology or where we've got medical advances in the law. We could have used this approach with RCN and DHSS as well to say, the Abortion Act, the whole purpose of it was to make abortion safe. And the nurses giving out pills is still keeping abortion safe compared to the backstreet abortions that we had prior to that. And again, just referring you back to that quote here from Lord Denning that I showed you at the start. And he was really in favour of this approach and saying that we should be filling in the gaps. Obviously, you're not expected to remember this whole quote, but I would be, trying to remember the key phrase that he used there, that the purposive approach allows judges to fill in the gaps. On the other hand, though, there are some disadvantages of the purposive approach. And these are, in essence, really just the same as the disadvantages of the mischief approach or the mischief rule. This rule gives, according to critics, too much power to the unelected judges. And when you think about what the judges are actually doing, they are refusing to follow the exact words of Parliament. In the case of RCN and DHSS, the Act clearly said registered medical practitioner. In the case of Jones and Tower Boot, the Act clearly said in the course of employment. But the judges, when they're using the mischief or the purposive approach, they are refusing to follow those exact words. They're saying, no, that's absurd, that's unfair, we're looking to the purpose. And Lord Scarman has criticised this approach, and there's a quote from him which is quite nice to throw in. He said, "We are governed not by Parliament's intentions, but by its enactments." And I do think he makes a really good point there, that obviously we cannot have Parliament's intentions, what's in their head, that cannot guide the judges. We need to have that written down. We need to have it passed as a law. You can't get inside Parliament's head is what Scarman's really saying here. And again, just like with the mischief rule, when judges are using the purposive approach, they are in essence becoming lawmakers. They are making, redrafting, however you want to phrase it, they're making law. And that's infringing the separation of powers. And remember, from our previous topic, Montesquieu was the theorist that talked about separation of powers. Again, similar criticism as we've seen previously with the mischief rule, that even if you use Hansard, finding Parliament's intention is not always easy. With the Race Relations Act, of course, I think it was pretty obvious what Parliament's intentions were. It was to protect black workers and people of other races in the workplace. That was clear what that act was trying to do. But with other acts of Parliament, the purpose might not be so clear. Parliament's intention might not be obvious, so that could be problematic. And if we are allowing judges to use Hansard to look at the debates of MPs when they're passing legislation, because that's what Hansard is, that can lead to prolonged examination of irrelevant material. You know, it's going to be time consuming. It's going to add to the cost and the length of the litigation. And that was something that Lord Mackay in Pepper and Hart warned about, that do we want to be dragging cases out, examining debates that were had prior to the passing of an Act of Parliament, when actually, really, we should be following the Act of Parliament. So, as with all the rules and all of the approaches, there are advantages and disadvantages. And now that we have looked at the 4 different rules or approaches to statutory interpretation, I think a really useful activity for you to do would be to come up with a grid, perhaps a little bit like this, with your rules and your approaches at the top there. So literal rule, golden rule, mischief rule, purposive approach. And add in to your chart your cases on each, and also to bullet point the advantages and the disadvantages of each. And remember, on exam 1, it's quite possible that you might have a 5 marker. So you could get a 5 marker asking you to explain the meaning of 1 or 2 of these rules. Or it might be to discuss the advantages or disadvantages, or potentially both, of each of these rules. But also be aware as well that on exam 1, you might get a 15-mark scenario type question where you've got a scenario given to you and you're asked to advise a character on what the outcome is likely to be, depending on which of these rules might be used. So you need to have a good understanding of all of these. So really good idea to come up with a chart to summarise all of these. And you may wish to go back through the videos and add notes to your chart at the end.